Good morning. It is 8:57 a.m. We're going to go on the record. This is the second regular docket of the month for the Oil Conservation Division. We're hearing approximately 14 status conferences today. I'm going to begin with case number 1 on our docket is 253. I guess someone's microphone is on. And you're only back for a short time when you're screwing things up, huh? This is case number 25312. It is Pride Energy. I think it is joined with some other cases. Let's take a look. Yes, joined to 25348. Ends 25. Hold on a second here. 25312 is not joined with any other case. I apologize. Entries of appearance, please.
Sharon Shaheen on behalf of Pride Energy.
Good morning.
Good morning, Mr. Examiner. Michael Felderwart, Santa Fe Office of Holland and Hart on behalf of EOG Resources, Inc.
Mr. Felderwood, are you monitoring or did you object?
We objected, and actually we have filed a competing pooling case.
Do you have a case number?
I do. It's 25455. And as Ms. Shaheen pointed out in an email yesterday, reminded everybody, we need to file a motion to amend the pre-hearing order to add that case, because I believe the case is set for a hearing on August 12th. Our case is scheduled to appear on the July 10th docket, just so it's on a docket in case anybody else shows up. So we can either wait till July 10th or we can file a motion this week to amend the pre-hearing order to add this case to the hearing on August 12th.
Or you can just make an oral motion today to amend, and it's granted. So Freya, would you issue an amended pre-hearing order to add case number 25455?
Yes.
Thank you. And then would you join that case number for the purposes of the hearing?
I will.
All right, perfect. Is that docket August 12th? Is that a trailing docket or is that the only one on there?
It's a trailing docket set to begin at 1:30 on the 12th.
Very good, 1:30. All right, so Mr. Felderwart, we are adding that case, amending the pre-hearing order, and we'll issue that pre-hearing order later today.
Just one matter of clarification is will the matter still appear on the July 10th docket?
Yes.
Okay,
It will.
right, because that's when it's been noticed. Great.
Freya, did you shake your head? I couldn't tell.
I did.
Oh, you did shake your head. I'm sorry. So Mr. Felderwart, maybe I give you the wrong information. What do you want to tell us?
It was noticed for July 12th, but I will move it to August 12th.
Okay. Now, is that okay? Or would you prefer it stay on July 12th?
It seems to me that it might be beneficial to stay on there in case there's other parties that appear, right? So that would be the only reason.
Freya, can you leave it on July 12th?
I can.
Oh, but July 12th is the hearing by affidavit, isn't it?
Yeah.
Right.
Yes.
So I did move it to the status conference docket already when I received the objection. I think that's July 24th. I can leave it on that docket.
That's a good idea.
Okay.
Ms. Shaheen, are you going to file an objection to that case in writing?
Yes, absolutely.
All right, I figured you would, but.
I think you get it right.
I think my assistant may have done that yesterday.
Okay. So Freya, did you hear that?
I did.
Okay. So so Mr. Felderwart, it'll be on the July 24 docket for a status conference. Ms. Shaheen, would you continue your case to that docket so that we hear them together? I know it's only, I know there's almost no reason to do this, but I think it's a good idea to have the new case on a docket before the actual special docket.
I will absolutely do that. And just to clarify, will we also need to move to continue it to the August 12th docket?
Yes.
So we'll need to file 2 motions for continuance.
Yes.
Okay, thank you.
Mr. Examiner, just for the record, I had entered my appearance in this matter for Red River Energy Partners, but we're just monitoring.
Would you say that?
Oh, Dana Hardy. Sorry.
Red River.
Yes.
Thank you. And you said you're monitoring?
Yes.
Thank you.
And Mr. Examiner, I'd like to enter my appearance as well.
Yeah. Did you want to
Carrie Hatley, entering an appearance on behalf of COG Operating and ConocoPhillips Company, and we are objecting to this case.
Okay. Did you want to spell your name for the court reporter?
Yes, Carrie, Keri, Hatley, Hatley.
Okay, so you are going to enter a written objection.
We already have
Oh, you,
in the Pride Energy case.
okay, in Ms. Shaheen's case?
Yes, sir.
Okay, now at the hearing, will you be offering evidence?
We will not.
Oh, will you be cross-examining witnesses?
I don't anticipate it, but I reserve the right to if I want to.
The parties never have to reserve the right, but you have the right. There's nothing to reserve. This is the administrative forum. Who's
Mr.
talking?
Examiner, this is Jim Bruce representing Kaiser Francis Oil Company.
Are you entering an appearance?
Yeah, I've previously filed a written entry of appearance.
I guess we didn't give the parties enough time to verbally speak up this morning. We won't make that mistake again. So, Mr. Bruce, objections?
Mine was just an entry of appearance, but I will be attending the contested hearing, and we'll probably have a position by that time.
Okay. Is there any other party that didn't get a chance to speak up? Okay. Ms. Shaheen, it's your case. How do you want to proceed? I mean, is there anything else you want to say before we go to recess?
No, I think we've all said it all. And I think we can move on.
Okay, good.
Thank you.
All right, we're in recess on 25312. Moving to number 2 and 3 on our docket, which are joined together. This is Avant Operating 25347, 25348. Entries of appearance.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2.
Good morning.
Good morning, Mr. Examiner. Michael Felderword, Santa Fe Office of Holland and Hart for MRC Permian,
Thank
who
you.
has objected to this matter.
Good, thank you.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Permian Resources Operating. And we have not objected. We're monitoring at this point.
Thank you.
Good morning, Michael Rodriguez with Civitas Permian Operating LLC, and we have objected to these cases.
Okay, good. Thank you, Mr. Rodriguez. Are there any other parties before we go back to Ms. Bennett? Not hearing any. Ms. Bennett.
Mr. Hearing Examiner, there is one other party, Paloma Resources or Paloma Permian Asset Co. And Palomian, if they're not on, I'll just say for the record, Paloma did object to the case being heard by affidavit, but has since withdrawn their objection.
And do you know who their counsel is?
Yes, Michael Jewell from Jewell Jimerson Natural Resources
Sheriff
Law.
in Colorado.
Mhm.
Huh. Okay. Freya, is Jewel part of the email that goes out?
I believe so.
Yeah, he's been on cases that we've heard in the past several months, so I'm surprised he's not here. All right. Okay. So they withdrew their objection.
They did on June 17th.
Okay. Where are we with this case?
So these cases, we Avant, my office on behalf of Avant filed the applications in early April requesting a May 8th hearing. Then MRC objected, Civitas objected, Paloma objected, but as I mentioned, has now withdrawn. And on May 22nd, we had a status conference in these cases. And at that time, Paloma indicated it might submit competing applications, which it has not done. And MRC and Civitas maintained their objection. And on that date, the hearing examiner set the case for a contested hearing on July 15th.
Mm-hmm.
And we came back today to talk about the status of whether any competing applications have been filed. And at this point, no competing applications have been filed by any party. So the only applications to be heard at the July 15th contested hearing are Avant's applications. And Avant still wants to move forward with the July 15th contested hearing. They, as we indicated at the prior status conference, Avant owns the majority of the interest in their units. They've been in discussions with Civitas and MRC. And as I mentioned, the case, we had a status conference in May, and the hearing examiner said that was plenty of time for the parties to negotiate, which is a proposition with which Avant agrees. And it's now time to go to the contested hearing on July 15th. I will say that this morning, Mr. Feldewart and I had a chance to confer, and it does seem like there's some room for discussions between Avant and MRC, but those discussions should not hold up the previously set contested hearing.
Okay, and you said that Paloma withdrew its objection and they haven't filed competing applications. Freya, would you know if Paloma had filed competing applications?
Only if they let me know that a certain case number was related to these cases.
Okay,
Mr. Hearing Examiner, I did review the July 10th docket, which is the only docket upon which Paloma could apply for to meet the deadline. And there were no Paloma cases, nor were there any Civitas cases. And there were a couple of MRC cases, but they were in a different county in different sections and townships. So in my review of the July 10th docket, there were no competing cases filed.
okay, so I'm just gonna go to Mr. Feldewart since he did file an objection. Mr. Feldewart, did you want to add anything?
The only thing I would add is, as Ms. Bennett alluded to, I know there was discussions between she and I that resulted from discussions between MRC and Avant. And I think the issue is the number of initial wells, okay, and that we're hoping to possibly cure by Avant filing an amended pre-hearing statement, which I think would be the most efficient way to go. But that has not been formalized yet, so they're still in discussions. But that's the issue that is a primary concern to MRC.
So MRC would like to see Avant drill either more initial wells or less initial wells. What percentage of ownership do you know what percentage of ownership MRC has in this?
Off the top of my head, I do not.
Okay.
I just know.
Do you know, Ms. Bennett?
Yes, I do. It's somewhere between 6 and 7%.
Okay. By the way, how much does Avant own in this acreage?
Avant owns 40%. They control 69%, and they're in discussions with another party to get 5% more. So they'll be at about 75% working interest control.
Perfect. Thank you. Mr. Rodriguez, you objected. Where are you?
So on Monday, an onsite was conducted at the location Avant intends to service from, and Civitas is still evaluating those results. And also, I believe the parties are working through a JOA now. So I'm hopeful that Civitas's concerns will be resolved in the coming days. And notwithstanding any unforeseen issues, I'm hoping Civitas will be able to withdraw its objection by next week sometime.
Okay. All right. Okay. Do we have Mr. Jewell or do we still not have Mr. Jewell? Freya, would you send Mr. Jewell an email just letting him know we heard these cases? He wasn't present. If he has something to add, he can hop on and I'll recall the cases.
Yes.
Okay.
Mr.
Ms. Bennett, we're on track for July 15. Is there anything else?
Yes, I did receive a text from Avant stating that Paloma Permian has signed a JOA with Avant, which may be why Mr. Jewell is not in attendance today because there's no further, they're in a voluntary agreement with Avant. And with respect to Mr. Feldewart's comments earlier, Avant and MRC have been in discussions about Avant's well plans, but it is my understanding that Avant intends to drill 6 initial wells, but they are not abandoning their full development plan. If that is the crux of MRC's agreement, Avant wants to develop the 6 initial wells, see the results, and if they are in the realm of what's expected, then they would move forward with all the wells under the order. So it wouldn't be that Avant would be removing wells from its application. It would just be that Avant would be willing to agree that there are 6 initial wells, but that all the other wells are still wells under the order.
Okay, thank you. Is there anything further?
Nothing further.
Okay, very good. All right, we're in recess on these 2 cases. We're going to move on to number 4 on our docket. It looks like Hillcorp Energy, case number 25376. And I think that case stands on its own. Enter your appearance, please.
Mr. Examiner, this is actually a case filed by Spur Energy Partners.
Oh, excuse me. Thank you. Is that your
Thank
case,
you.
Ms. Barr?
It is, yes.
Thank you.
So Dana Hardy with Hardy McLean on behalf of Spur Energy Partners.
Okay.
Good morning, Mr. Examiner. Miguel Suaza with Beatty and Wozniak, appearing on behalf of Hillcore Energy, Overton Energy Investment 6, and the Salient Zarvona Energy Fund.
Excellent. Thank you, Mr. Swazo. Did you object, by the way?
Yes, we did. All three
Okay.
parties objected.
Okay. And what's happening with your objection?
Do you mean the basis for the objection?
No, I don't need to know the basis right now. Are you maintaining your objection?
Yes, Mr. Examiner.
Okay. And are you in discussions? Do you know if your client is negotiating with Spur?
So I think it varies across the three clients. I know that Hillcore is still trying to gather additional information from Spur. Right now, they're not particularly comfortable that the horizontal wells that are proposed won't impact their vertical wells. So I know that with respect to them, the discussions are ongoing. And with respect to Zarvona, it's more of a concern about the interest that they hold in relation to the size of the interest that Spur has. And so Zarvona is particularly experienced in this area and in drilling these types of wells, and they have a larger interest. So I know that, they've spoken to Spur, and Spur's kind of refused to make some commitments that Zarvona would feel more comfortable with. So in that respect, discussions are ongoing, but I don't think that they've been resolved to date. And with the final client, Overton Investment 6, their objection stems from Spur's unwillingness to provide a JOA and kind of some of the terms that would be incorporated, particularly marketing fees. So I know that they're speaking as well.
Okay, perfect. Thank you, Mr. Swaza. Are there any other parties that you know of, Ms. Hardy?
Not that I know of.
Okay. How do you want to proceed?
Mr. Examiner, I think Spur would like to have this case set for a contested hearing, preferably in August. I think that they're working with Hillcorp on the technical concerns. They have provided a JOA to Overton and Zarvona, and I don't believe that Zarvona has drilled or operates any wells in this area or in New Mexico for that matter. I'm not sure that they're a licensed operator. And so competing applications haven't been filed, and we would ask this to be set for a contested hearing, preferably on August 12th or 13th on the trailing docket.
Did you just say that competing applications were filed?
Have not been filed.
Have not been filed. Thank
Right.
you. Freya, the first date you give me to offer is August 26th. Now, Ms. Hardy is wondering about the 12th or 13th. Are we not able to offer earlier than the 26th?
We already have 3 hearings set for the August 12th docket, and we start in the afternoon on the 12th, going into the 13th, so it might be tight.
You hear that, you understand the problem.
I do.
It looks like August 26th is our first possible date. Does that work for you?
That will work.
That will work. Okay.
Yes. Thank you.
Mr. Swazo, August 26th, if your clients continue to maintain their objection?
Well, I want to make sure that Zarvona especially has time to submit competing applications, and I guess that technically gives them enough time. Just out of curiosity, what's the first available docket in September?
The first one in September is the 2nd.
Okay, well, that's not enough of a material difference, so I guess August 26th is probably acceptable.
Okay, and so of the 3 clients, the Zarvona Energy Fund would be the one that would potentially file competing applications.
Well, I don't think necessarily, but I think they're probably the most likely. Again, I think it depends on the conversations that continue to be had and how they pan out. But I do think Zarvona is most likely to be in that position.
Do you know what their ownership interest in the subject lands is?
Yes. Let me see if I can find that. Zarvona's interest is 15.375%.
Okay,
And Spurs is 12.4%.
perfect. Thank you. Ms. Hardy, do you agree with those figures?
Spur is in the process of acquiring additional interest, so they would have significantly more interest than that by the time we got to hearing.
Okay, but that figure is correct as of today.
It sounds approximately correct to me.
Perfect, thank you. Yeah, thank you, Mr. Swazo. Appreciate the figures. All right, so we'll issue a pre-hearing order, Ms. Hardy, for August 26th. Freya, is that a trailing docket or is that the only case on that docket?
It's a trailing docket.
Trailing docket. Okay, gives plenty of time for negotiation with these three interests, gives Zarvona the ability to file competing apps in a timely fashion. Is there anything else, Mr. Swazo?
No, Mr. Examiner, thank you.
Ms. Hardy?
No, thank you.
Good, we're in recess on that case. Moving now to number 5 on our docket, it is Matador Production Company. It looks like we have a few cases here. Looks like we have a motion hearing. The case numbers are 25247, 48, 25250, 5253, and 54. Entries of appearance, please.
Good morning, Mr. Examiner. Michael Felderward, Santa Fe Office of Holland and Hart for the applicant MRC Permeate Company.
Okay, thank you, sir.
Jonathan Samaniego, representative of American Energy Resources.
Okay, thank you, sir.
Good morning, Mr. Examiner. Darren Savage with Aberdeen and Schill on behalf of Alpha Energy Partners 2 LLC.
And Mr. Savage, I already know what Mr. Samaniengo's position is. I forgot your position.
So we did an objection.
Didn't.
We did.
Did.
We did enter an objection where it looks like competing applications are going to arrive. Alpha was looking at doing competing applications, but they have an AMI.
I don't know what AMI means.
Okay, that's an area of mutual interest. It's a agreement. So like you carve out, you look at several townships, or you look at several sections, and then you do an agreement where if parties go in and they lease, that they agree to share the percentages of that. So it's an area of mutual interest that they're developing, and it encompasses these areas that are going to be contested. So Alpha was planning on doing a competing application, but it looks like Mewburn is going to be the one leading that effort and be filing the competing applications. So this is a kind of a rather complicated matter. I don't know anything about Mr. Samaniago's motion and do not support it, but Alpha believes, looking at this and talking with my client, there may be separate grounds for dismissing MRC's applications at this point that we'd like to be able to address and discuss with Mr. Felderward during this.
So that's fine. We have as much time as we need to discuss these things. But so you're representing Alpha. Who's representing Mewburn?
That
Mr.
would be
Examiner, Ms. Bruce represents you.
Mr. Bruce, did you enter an objection?
No, I didn't. I did not enter an objection at the time because Mewburn at that point was just an observer. It did not receive notice of the application from MRC, and it had not received a well proposal. But we can get into that in a little more detail at the time. But Mewburn will be filing competing applications. And if I may, just to clarify, MRC's applications cover all of sections 27, 28, and 29. And Mewburn's applications will cover the west half of section 29, all of section 30, and all of section 25 in the adjoining township. So really what's at issue is really a half section of land, the west half of section 29.
Not the east half of 29, the west half of 29.
Correct.
But you said okay, I guess that's not really critical for me to understand right now. Okay, so would you please enter a written objection if that's your position?
Yes, sir.
All right, good. And then when do you anticipate filing the competing applications?
Well, my understanding from the prior hearing was if Alpha was going to file, they had to file by tomorrow to get on the July 29th special docket.
Okay,
And I informed Mewburn that they would have to file by tomorrow.
okay. Okay,
And I will probably follow up with an email to Brea when they are filed, just to make sure that they're not set on the docket for any other docket.
so you wouldn't want them to be heard, not heard, but you wouldn't want them to be noticed for an earlier docket before July 29th?
Well, what is the second regular docket? We could do it that way, but I don't.
Well, I just think it allows for any kind of objection from another party or just pre-hearing preparation. But what is it? I don't know what it is. Fred, what is the second docket of July?
We only have one hearing by affidavit docket in July that would be noticed for new cases, and that's July 10th. The deadline has already lapsed for that.
Okay,
So the next docket that would be normally noticed would be August 7th. Since these are competing applications, I could prepare a special notice just for this one competing application for July 29th.
I see. Okay, Mr. Bruce, you heard that, right?
Yes, sir.
So so we would be going above and beyond what we normally do to get these to be joined for the July 29 contested hearing. So please make sure you're in communication with Ms. Chance, and also file a motion to consolidate once you have filed the competing applications.
Yes, sir.
Mr. Felderworth, we're back to you.
Thank you.
Yeah.
So I'm a little confused. So our applications are laid down covering 27, 28, 29.
Okay,
Mr. Bruce said his are going to cover, and Mr. Bruce, correct me if I'm wrong, 29, 30, and you say 31?
no, 25 of the next township range.
The next township. Okay. So
The
is the overlap?
Mr. Felderworth, west half of section 29 only.
Which I don't understand either. I thought it'd be the east half of 29. Because I would think that would be what abuts to 30, but I don't have a map in front of
Okay,
me.
yeah, I don't either. Okay, well, we'll see whatever it is. But my point being is that they're now adding to the case that's docketed additional acreage, which would be additional pooled parties who have up till now most likely not been informed of Mewburn's plans. So it would seem to me that we would want to have it filed and have it scheduled for a docket before July 29th to see if there are other parties that appear and may have development plans that compete with other Mewbourne acreage.
Mr. Bruce?
Well, yeah, but I theoretically, I have no objection to that, but I guess that would have to be, today is the 26th. That would have to be July 26 or 27 because of the 30-day application filing timeline.
Have the well proposals gone out?
Mr. Felderworth, I presume so. I have not. I do not know. I was contacted so recently, I do not know.
Well, Mr. Bruce, do you have a way of contacting your client? We can go into recess.
American objects, if he didn't come prepared, he doesn't have relevancy to proceed. And to wait on for his client would cause burden on other affected parties. So I'm going to object to Mewbourne proceeding at this time until he gets his documents in order. Until then, I respectfully request to proceed. I also object to Alpha's proceeding because there has been violations in their antics in cases 25166 in their farm out for many violations regarding state law. A hearing for de novo hearing will be filed in that here shortly. But as far as today, I'm objecting to Alpha proceeding because of their continuous violations of state law in their antics to profit.
Okay, Mr. Samaniego, before you continue, sir, before you continue, Freya, please mute Mr. Samaniego. Mr. Samaniego, when you hear me start to speak, I'd prefer that you stop speaking. It's going to make this a lot easier for both of us. The court reporter needs you to state and spell your name for the record. So let's turn on your microphone, please, and do that. Mr. Samaniego, you have to turn on the microphone. Once Freya turns it off, she can't turn it back on for you.
Jonathan Samaniego, JONATHANSAMANIEGO, representative of American Energy Resources.
Okay, thank you. Now hold on one second. Did you get that? You got that. Okay. So, Mr. Samaniego, let's take this one step at a time. What I asked Mr. Bruce to do was to contact his client and find out if well proposals have been mailed out. That's all I've asked him to do. So we're having a motion hearing today on MRC's motion to strike you as a participant or a party to this case. So that is what we're doing today. If you want to file written motions for other things, you're more than welcome to do that, and we'll hear that at a later date. But I have received your filings. I did receive your filing on 6/24. I received, this is your motion to dismiss. I think I have that in front of me. I also have your docketing statement for the Court of Appeals, dealing with the judge's order down in the 5th Judicial District. So I have that information. I also have the document that you filed a motion to strike back on 6/6. So I have a bunch of documents that you have filed that we need to deal with today. I also have MRC Permian's motion to strike you as a party. You filed a response. I gave MRC an opportunity to reply. They didn't take me up on that, which is fine. They don't have to. But before we get to the motion, I do want to deal with these competing applications. So, Mr. Bruce, I agree with Mr. Felderwert that if you're filing competing applications and it's going to encompass new lands, which obviously it's going to, then we need to have this on some docket before the contested hearing on July 29. So we need to work this out. Do you have any suggestions, Mr. Bruce?
Well, two. Number one would be if the applications are filed by tomorrow, that would be 30 days to July 26th to set them on that docket to see if there are any further objections.
Okay.
The other one would be, and I doubt that MRC favors this, would be to set this for the August 7th docket. And that would probably entail amending the pretrial order to set another contested hearing date.
Okay. So Freya, are we able to get these competing applications which have yet to be filed on the July 26th status conference docket?
It's July 24th is the status conference docket. The 26th is a Saturday.
Thank you. July 24.
Mr. Hearing Examiner, there's some additional information that may impact the selection of the date. So, for example, in that section 29, that's a very difficult, messy title. And there's leases that have terminated by their own terms and gone back to so there's unleased interest in there, in addition to a number of changes of ownership. So Alpha has not received its well proposal at all.
From who?
From MRC.
From MRC.
That's correct. I don't believe Marathon has received, I'm sorry, not Marathon, Mewburn. I do not believe, Mr. Bruce may clarify, but do not believe they have received theirs. There's 5 other owners at least. Some of those are landowners who have no sophistication about the oil and gas industry. I know that Pegasus Resources, McMillan, City of Carlsbad, the Estate of Ruth McCree, Estate of Paul Williams. These are all folks. Now, what's interesting, so typically when you have so you have a couple of scenarios. Like you have one scenario where you have, let's say, an oil and gas company that has a lease. They receive a well proposal, then they assign it to somebody else during the interim while they're, so you have another oil and gas company. And in that kind of scenario, you usually get the oil company goes through due diligence, and usually they would know that the well proposal was, the lease was subject to a well proposal, and then you would have, they'd be aware, or they should have been aware. In this scenario, we have leases on the lands, and I believe, if my client is correct in this, that Marathon and ConocoPhillips may have been the lessees at the time that the well proposals were sent out. So you have leases, and then you have some event, and I believe it was a missing shut-in payments or something like that terminate the lease. So the lease goes back to the landowner. Then in our scenario, then another party came along and leased the interest, and then that party assigned it to another company, assigned it to Alpha. So we have like several intermediaries. So you don't have that continuity of potential notice that you have in the previous scenario that I described.
Doesn't the rules, and I don't have the rule in front of me, but doesn't the rule say that it's the responsibility of the applicant to send notice that they know or should know based on records, et cetera, at the time of the filing?
Well, this is the well proposal. So actually the special rules on well proposals say that you should send, really need to send a well proposal 30 days before you file the application.
Sure.
Okay. Then there's language in there about extenuating circumstances.
Mm-hmm.
And so and the purpose of the well proposal is to get the parties to reach a voluntary agreement prior to the forced pooling. So there's extenuating circumstances. So you can shorten that period and still maintain notice and correlative rights and all that. But it looks to me like what you can't do under the terms of the order is you can't file the application prior to sending out the well proposal.
And who did that?
We believe that MRC did that.
Oh, I see.
Okay.
Mr. Felder, there's a lot here for you to deal with before we even get to the motion hearing.
So let's see, Mewburn entered an appearance in this case in May.
Okay.
Mr. Savage, do you know when you appeared?
Let's see here. We appeared.
There we go.
Looks
You
like
appeared in
May 21st, somewhere there.
They appeared in May.
Yeah, May 21st.
May, June, etc. So long before you heard this matter and set this case for hearing on July 29th. None of this, to my knowledge, I haven't combed the record, but none of this was raised. So this is all a complete surprise. I wonder why Mewburn, who appeared in May, didn't indicate that they were filing competing applications till now. I wonder why Alpha apparently has this knowledge about title that apparently nobody else does, why they didn't raise this sooner. So this does come as a complete surprise. I would say it's fairly tardy, given that you've already set this for a hearing on July 29th. So that's all I can say now, because I don't know what the heck they're talking about.
Do you know whether MRC did send out proposals before it filed its case?
I'm sure they did.
Okay,
I'm sure they did. That's their normal routine.
right,
That's something we check before we file the application.
okay,
Okay. So yes, I'm sure they sent out well proposals to the parties of record as shown by the title records in the county where the property is located or otherwise known to the company. Okay. Same as you do for notice of the hearing. Mewborn got some kind of notice because they were here in May. Alpha got some kind of notice because they were here in May. None of them raised any issue about not receiving a well proposal, and none of them raised any issue about any title concerns.
okay. So, Mr. Savage, so Mr. Bruce, let me come back to you for a moment. Are you saying your client did not get a well proposal?
No, they did not. Now, that goes to Mr. Savage's point. Mewburn has an interest under this area of mutual interest agreement, but at the time, they did not have any plans. They were looking at acreage to the east, and Mr. Savage's client would like the west half of section 29 included in the well unit. So there was a lot of moving parts here. And so there was no evil intent on Mewburn. They were just interested in what was going on at the time. One thing I did just confirm with Mewburn that they have sent out well proposals on their acreage.
Do you know when?
I did forget to ask that, but it was within the past week I was informed.
Okay. Wow. It feels like I don't have all the information here that I need to make some sort of decision. Mr. Bruce, I don't have the rule in front of me, but does the rule say that, because we have a 20-day notice period, and I think you have to notice people as well before we put something on the docket. Is it 30 days in the rule or 20 days in the rule?
Well, it's 20 days for notice, but I have to file the applications 30 days before the hearing date.
And that's to give the OCD time to give notice for 20 days before?
Well, that's just in the rules that the applicant has to file notice 30 days before a hearing date.
Okay. And then we have a policy of sending out proposals 30 days before you file.
We have to mail out notice 20 days before the hearing date.
That's not what I'm asking. Okay, all right, but that's okay. I understand.
Mr.
It
Hanks.
is June 26th. This hearing is scheduled for a month and 3 days, basically, from now. So, Mr. Bruce, yeah, tomorrow's your deadline to file your competing applications.
Correct.
And unless there is something, unless I don't have the discretion to put those cases on the July 24 docket, if someone wants to make an argument why I can't do that, I know the rule says 30 days before, but it would still be 30 days before July 29. I would like to get these on the July 24 docket so that other parties have an opportunity to look at your applications and make objections or whatever. So, Mr. Bruce, is it within my discretion to list your competing applications that you're filing tomorrow on the July 24 docket for an initial for that notice, and then to have you continue them to July 29?
Mr. Examiner, it seems to me for a party before the division has the right to request an exception to any rule of the division, and I could file a motion today to ask that the 30-day period for notice, period, be revised to what, 27 days? And allow it to be set for July 24th? Would that be?
Sure.
I
What are
see
the,
no problem.
okay, so what are the extenuating circumstances in this case?
I guess it would be the number one, as Mr. Felderwerk pointed out, for an acreage involved, and we need to see if anybody else has an objection before the July 29th, the scheduled July 29th hearing date. And there is still time to get out the 20-day notice. Mr. Examiner, I would note that historically, when I started practicing before the division, the actual time schedule for filing an application was 20 days before a hearing date. So the division changed that,
Okay.
two and a half or 3 decades later. So, there's nothing magic about the 20 or 30 days. It's just
Okay. I understand, Mr. Bruce. Yes, file that motion, please. But put in there the position of the other parties, including Mr. Samaniengos, who I believe he objects to just about. Yeah. So I believe he'd object to that. But we'll hear from him in just a moment. Mr. Felderwerk, do you have any problem with that?
Well, I think it'd be cleaner if they could file their applications tomorrow.
Well, they're going to. He said he
As opposed
would.
to a motion.
that will be done. I will
Okay.
file the motion today.
So then,
I
if they
will-
file the applications tomorrow, they would be timely filed for the July 24th docket. Then notice will go out 20 days before that July 24th docket. So I fail to see the need for, what are we filing in a motion? I missed that.
Asking for exceptional circumstances to the 30-day period. The rule says you have to file an application before.
They're going to be filing 30 days in advance of the hearing. There's no exception.
I would agree with that for the 29th of July, but we're going to be listing it on the 24th, 5 days before.
Right, but they can file for the 24th tomorrow.
Definitely,
Okay.
definitely. But that still wouldn't be 30 days before July 24 is all that we're talking about.
It would be, wouldn't it?
I don't have the
Am I missing
calculation,
something? Maybe my math is off here. Okay, if you might be correct.
and I'm not doing any math, so
Okay, you might be correct. That's fine. I don't object to that
Great.
process.
thank you. Mr. Savage, any objections to what
Well,
Mr. Bruce is going to do?
If you don't mind, I'd like to respond to Mr. Felderwerk's comments about my tardiness.
Okay, but I'm asking you a specific question. Do you have any objection to Mr. Bruce filing his applications tomorrow for the July 24 docket as a status conference and then to be consolidated for the July 29 special hearing?
So I don't have any objection to the filing of the applications tomorrow, but I would have an objection to having the contested hearing on July 29th.
Well, they're not your cases. They're Mr. Felderwerk's cases.
We're a party, we're a party of interest, and we believe that Mr. Felderwerk's, that the application should be dismissed.
Well, then file a motion right away so I can, we can get a response from Mr. Felderwerk and then we can deal with that.
Okay, and the motion would include response to his comments that he made on record.
Fine. If you
Is that something that I could address on records in response to his comments that he made on record?
If you feel the need to, go ahead.
Okay, thank you. So Mr. Feldwerk, so Alpha did file its entry of appearance and objection on May 21st, and we did announce that competing applications would be coming. So, and we did file our objection. Then we never received a well proposal, but we did monitor. Alpha does monitor the docket, and that's how we were aware, and that's how most parties who don't receive their notice properly become aware. So after that, Alpha and I believe Mewburn began discussing how to proceed, as I understand, they actually informed MRC that there were defects in the well proposals not being sent out, and that there were defects in the title, and that should be addressed. So MRC was fully aware of these defects well before today. In fact, Ms. Vance actually emailed me, and Mr. Veldor was on that email and said, "Hey, what's going on about the upcoming status conference?" And I checked with my client, and I responded to them that Alpha and Mewburn were discussing these matters. It's getting very complicated, and it would be a good idea for MRC to be involved in those discussions. So, as I understand, they were involved in those discussions. They were involved in some discussions. So, if counsel for MRC is unaware of this stuff, I think that's a communication problem between MRC and counsel. But MRC should be fully aware of these defects. And I believe that I look at the rules, and it looks like to me like you cannot, even though you may shorten the time period for the well proposal for extenuating circumstances, you cannot file an application prior to sending out the well proposal. That seems to be a bright line that you cannot cross. So it looks to me like the application should be dismissed and reapplied, or that MRC should do some motion to ask for an exception to allow more time to send out the well proposals and then move everything down the road just a bit to allow for proper well proposals and for negotiations with the working interest owners that were overlooked.
Thank you. Mr. Veldor?
Well, the only immediate response is that the MRC filed their application in March, which meant the well proposals probably went out in February. They went out in February to parties of record in the county and where the property is located in February. And I'm just guessing. My guess is if Alpha thinks they have an interest or has an interest, that perhaps there wasn't anything of record in February when the well proposals went out to indicate that they do. So he can file whatever motion he wants to, but that would be my guess.
Okay, thank you. All right, Mr. Savage, it's on the record.
Thank
Your
you.
response to the timeliness of your objection. If you have evidence that shows that well proposals did not go out to at least who they thought was the record title owners, file it. Otherwise, Mr. Bruce knows what he's doing. I understand your position. Now we need to deal with this motion to strike. We've had several motions. Well, actually, we've had many motions in this case. I'm just going to review some of the history in this case since it's a little it's out of the ordinary. So these applications were filed March 10. We received an entry of appearance and objection from Mr. Samaniego on, well, there's no date on this, so let me go back, on April 14. Then Mr. Samaniego filed a motion to strike these applications, and I'm just going to shorthand this because I know you weren't here, Mr. Felderwert, but I've dealt with this by order. Ms. Vance was here already dealing with this, and this was that basically your client was not following the rules, and that they had wells that were out of compliance, and that because of that we should dismiss the applications. I denied that motion to strike because I informed Mr. Samaniego that he does not have standing to enforce the rules of the OCD. Only the OCD has standing to enforce its own rules. There's nothing in the rules that gives a private right of action to anyone. Okay, so then we had a motion to strike filed on May 20th, asking me to strike American Energy Resources entry of appearance and notice of opposition based on the following. I don't know if have you reviewed this?
I have reviewed the history, so
you know this already.
I'm familiar.
You're familiar. Okay. Do you want to summarize this motion and the bases upon which you're asking me to strike so that Mr. Samaniego can hear? Because then I'm going to go through the responses and everything else.
So I think you're correct. The only matter for the division to address now is MRC's motion to strike American Energy's entry and objection in these cases. If we filed our motion demonstrating, we believe that they do not have a basis to intervene in this matter. We showed that they're not seeking to pool Mr. Samaniego because we don't show him as being a interest owner of record. Secondly, there was a district court decision that determined that American Energy and Samaniego did not own any interest in the west half of Section 27, which is where they claimed their interest. And that district court case involved the Dowling lease, which is one of the mineral owners of record there for which MRC has a lease and is proceeding to develop that acreage. I saw that he submitted a response on the day of the status conference where he conceded the district court had issued its ruling. He conceded that it involved the Dowling lease. He said he had appealed it. His transcript said you found his claims a little confusing, inconsistent, somewhat lacking in substance, but gave him another chance to file his a response to the motion to strike. And when we looked at it, there was it didn't raise anything new, and in fact, alone demonstrated it itself demonstrated that his motion should be denied. And when you look at what he has filed, I was going to bring it up on my screen. If I can, there we are. If I may share.
I'm looking at the document that was filed on June 6th. Is that what you're looking at?
June 5th.
6th. I have the 6th.
Okay, fine. If I can share that, yes.
Please do.
Okay. When I look at this, really what he's suggesting is that he should be able to intervene because he still claims that he's an interest owner in the acreage in the west half of Section 27. And he says he has APDs, applications to drill for 4 vertical wells. Now, when I look at what he filed and I go to, for example, PDF page 6 of what he filed, he provided the agency with the summary judgment from the district court indicating he has no interest in the acreage. And the acreage that they were addressing, as you can see in the highlighted portion, is the west half of Section 27. The court ruled that that particular property that they described in their ruling was established in the plaintiff, which was Ms. Dowling. Okay. And the court found, you'll see down at the bottom, that the deeds, that Mr. Samaniego was claiming an interest in, that the court found that those deeds are unenforceable, voidable, void, null, and of no effect, and they are hereby stricken from the real estate records. Okay. So that's where we stand now. The instruments into which he's claiming an interest are stricken from the real estate records. And that the title records show that Ms. Dowling owns the interest, and under that lease is what MRC is proceeding under. So that's the state of the record. So if you look at the state of the matter now, he does not own an interest, period.
Would you take a look at paragraph 16 of the order for summary judgment?
Yep.
Would you read that?
To myself?
Out loud.
Okay. Defendants admitted the relevant facts in their deemed admissions. Defendants American Energy and Black Gold admitted the deeds at issue, and those are exhibits A, E, and F, are void and voidable. All of the defendants admitted defendant Samaniego is the alter ego of the Black Gold and American Energy. The same counsel represents all defendants. Accordingly, the admissions of Black Gold and American Energy are binding on defendant Samaniego herein.
Now, these deeds at issue, exhibits A, E, and F of this, do you know whether these deeds, exhibits A, E, and F are what give rise to the claim of an interest in this?
That is what Mr. Samaniego has attached to his motion as the basis for his interest.
That's what I thought.
There's A, E, and F for the summary judgment. Okay. If I go down to PDF, which he marked as exhibit B, which is page 18 of the PDF, it's the same mineral deed that the court said is void, stricken, no longer valid.
Well, right, but did defendant American Energy and Black Gold admit that the deeds are void and voidable?
Per the district court judgment, yes.
Yeah. Okay. Now, okay, so before I go to Mr. Samaniego,
and I do have a little bit of secondary.
I don't know that I need a secondary at this point. Now that this is on appeal and Mr. Samaniego provided a docketing statement showing that this is on appeal, does that automatically stay the district court's decision?
No.
No.
It does not, number one. Number two, it doesn't change the district court decision. Number three, the only thing that the division can go on is the status of the real estate records now, just like every other person in this room. And the fact that someone is appealing it and suggesting that they might be able to overturn it does not change the status of the records.
Now, the attorney, Mr. Samaniego's attorney, could file something in the Court of Appeals asking it to stay the district court, couldn't it?
Well, I don't know if he could ask the district court to stay its decision because there's no action being taken. There's nothing to stay.
I thought that the district court was instructing the county clerk to remove anything from the records. Didn't you just say that?
Well, it said it shall be stricken.
Right.
Is stricken.
Right.
Yeah, period. Now, I don't know if that means the clerk has to do
I
anything. That's beyond my level of expertise.
Okay.
But they've not done anything other than the appeal.
Okay. Mr. Samaniego, is your microphone on?
Yes, sir.
Okay, great. So, Mr. Samaniego, so you've heard the argument to support the motion to strike your entry of appearance and your objection. And basically, it's based on the district court's order, as Mr. Felderwert just reviewed with you just now, and also in writing earlier. I know that you're appealing the judge's order, but at this point, the judge's order is in effect. What do you have to say about that?
I'm going to say that Mr. Feldwart, his review was very brief. So I'm going to say he didn't get the full understanding of the matter. But I'm going to move forward and say that the judge's ruling and order, if any ruling for the order violates state law, it's null and void. And because the judge's order was in violation with state law, one, with violation of due process, which is unconstitutional by federal law, regardless of what New Mexico thinks. Second, the plaintiff awarded the property is an unaffiliated party of the matter. Mr. Simpson, I don't know where he got involved in this matter, why he was awarded property unaffiliatedly, or why they felt he needed to be awarded these properties. when he was an unaffiliated party. There's many violations of state and federal law that occurred in this matter in district court. And because of the facts that have been brought forth, the district order is null and void, and the appeal stands along with Mr. Samaniego and Americans' interest in the lands.
Mr. Samaniego, I don't have anything in front of me, any authority in front of me to disregard the district court's order. I know that you have an issue with your due process rights in front of the district court, and I realize that that's one of the bases of your appeal to the Court of Appeals. You felt as though the district court didn't handle the matter fairly toward you. But I have no authority that says I can just ignore a district court's order. Do you understand that?
The plaintiff in the district court order, it was granted to William Scott Simpson, who's a dead guy. He's deceased. Why was this property awarded to an unaffiliated party who is deceased?
So the part of the district court order that I am focused on is the part where the court adjudicates this matter to the plaintiff and finds that you don't have an interest in this acreage.
Under state law, under state law, if the order violates state law and federal law, it is null and void. There were numerous violations that border. I really don't want to say certain criteria of what happened here, but it was negligent. I mean, there was a lot of gross negligence that occurred. That judge's order is null and void. It's not able to be upheld. That's a violation of state law. To uphold an order like that is a violation of state law itself. To assist in a gross negligent matter that grossly affects collective rights and interest owner.
Okay, all right. I noticed that Mr. Candelaria is not here representing you today.
I'm aware of that, and he told me that to handle it today, and that he is going to see how this matter is handled, and then we will proceed.
Okay. Okay. So based on the court order, my hands are tied, Mr. Samaniego. I cannot disregard an order, even if you feel that it's void under federal law or some other type of law. I can't ignore a court order, sir. So I'm going to grant, so Mr. Samaniego, I'm going to grant MRC's motion to strike. And if you find that you don't agree with that, when the order is issued in this case by the division, you have a de novo appeal to the commission, but you have to wait until the administrative process plays itself out and a final order is issued, either awarding MRC its compulsory pooling or awarding it to Mewborn or some other applicant. But that's my decision at this point. And so we're done with this motion. So Mr. Felder, would you please draft the order?
Hold on. I'd like to request an oral motion for stay on the matter until the district court and appeal has been resolved to protect collective rights that can be grossly affected.
Well, Mr. Samaniego, first of all, you're not being force pooled in this matter at all. So did you know that?
MRC's lease has been terminated under the own terms of the agreement.
Okay, Mr. Samaniego, but you're not being force pooled. Mr. Samaniego, you're not being force pooled here, so your correlative rights are not being impacted by the eventual order of the division.
American is being pulled. They're drilling right through the lands. To say that they're not pulling the interest is just trickery and sleight of word.
Well, thank you, Mr. Samaniego. I appreciate your participation today. So, Mr. Felderwart, please draft an order, a proposed order, and send it to
Just for
me.
clarification, how much time do we have it for the appeal, for the appeal to be filed?
Ms. Samaniego, you should speak to your attorney. I can't give you advice on what to do.
You've been helping everybody else with advice.
Thank you, Mr. Samaniego.
And everybody
Freya,
who's represented.
would you please mute the microphone now?
now?
Okay, the motion is finished. We've dealt with it. Is there anything else?
I will send a draft order.
Okay. Of course, please circulate it to Mr. Samaniego.
Yep.
And other counsel for their positions. But is there anything else in these cases today?
Yes, Mr. Examiner, I filed a second motion to strike for MRC being in violation of state law with their numerous well violations, and to allow MRC to proceed would be a violation of state law itself under 1915-5-8, where the division is charged with the duty to protect public health and the environment, and to allow MRC to proceed with this pulling hearing and to drill more wells when they currently got more wells and violations than they can handle would definitely fall under the lines of gross negligence under public health and environment, not protecting either one.
Thank you, Mr. Samaniego. As I advised you at the last motion hearing we had, you don't have standing to enforce state rules and state statutes. Is there anything further on these cases?
No, sir.
Okay. Mr. Savage?
No, thank you.
Mr. Bruce?
No, sir.
Okay. So, Mr. Bruce, you're filing a motion today
Yeah.
based on the time frame that we discussed. You're filing your competing applications tomorrow. They will be listed on, they will be noticed on the 24th of July docket for a status conference only, and then you'll move them to the July 29 for a hearing.
That is correct.
Is there, okay. We're off the record in those cases.
Hold on, Mr. Examiner, you didn't let me finish. I would just like to be on the record that, Mr. Examiner, are you willfully violating 1915-5-8, the enforcement of the statute of rules where the division is charged?
Freya, would you please mute the microphone of Mr. Savage? Thank you. Okay. We are now moving on to the next set of cases we have. This is number 11 on our docket. This is WPX Energy Permian Compulsory Pooling Case 25204. Let me see if it's joined with other cases. I believe it is. I think these are 4 cases, 25123, 25124, and 25205. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Darren Savage with Abbott and Schill, appearing on behalf of WPX Energy Permian LLC.
Thank you.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing on behalf of 3R Operating.
Thank you.
And good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of Marathon Oil Permian, and we are monitoring only.
We had this hearing, we had a 2-day hearing at the end of April. This is basically a hearing to make a decision on WPX's motion to reopen the record and admit 2 documents, basically. So, Mr. Savage, I have a question. First, let me get your motion in front of me. I don't have it here. And Mr. Savage, I believe you filed, this is a little confusing for me because the way the filing is working in these combined cases, when you file your motion, it's only in your cases. It's going in all the cases?
We filed, it pertains to all, because 3Rs did a response, and so we filed in all 4
Okay.
cases.
I'm not sure, did 3R do a response?
Well, they did, but they took no position.
Okay,
So that was their official response.
okay. And give me a moment here. Let me pull this up because I have a couple of questions for you and Mr. Suazo. Okay, I'm in 25204, just for everyone's knowledge. The last document I have in 25204 is the motion. I don't have Mr. Suazo's response, which I did see yesterday. And Mr. Suazo, my understanding is you take no position to expedite the decision in these cases. Is that right?
That's correct, Mr. Examiner.
Is there anything else you want to add to that?
Well, yeah, I mean, I think, we talked it over and, our sense is that this motion to reopen essentially belies, the weakness of WPX's case. And we've been prepared and are prepared to drill these wells as soon as an order is issued if we're awarded. And so, the question is, if you decide to open up the case, I think that 3R would like for the grounds for reopening to be as narrow as possible. What that look like, I think we can discuss, but, I think whatever the basis for letting in these documents would be if the case is reopened, they shouldn't be used for, anything beyond, what they state.
I'll object to those comments. It sounds to me like 3R is taking a position on the matter.
Well, I've asked for his position, and he said,
In his response, he was saying he'd take no position, and now he's arguing over parameters and qualifications, and to me that sounds like a position.
okay. All right. So, Mr. Savage, this is not evidence, first of all. This is just argument, number one. Number two, I do want to hear from Mr. Suazo. So I overrule your objection. Thank you for speaking up timely. So, Mr. Suazo, I did see, I reviewed your revised exhibit packet that you filed. I believe it was May 21st or somewhere in that neighborhood. In that revised exhibit packet, I did see several instances where you, in red letters, notified the division that this federal oil and gas lease, NM 134858, was set to expire on October 1st, 2025. Now, I want to hear from you. What was the purpose of giving us that information of the expiration?
Well, as we stated in the hearing, the concern when these applications were filed and then WPX, filed their competing applications and objections was that this order would be kicked to a point in the year when these leases would actually expire. And so time was of the essence. And as of the day of the hearing, the last day of the hearing, the BLM had not taken a position. And we made clear at the hearing that an extension of these leases was not a foregone conclusion. And so time was of the essence to make sure that an order was obtained so that 3R or WPX would be able to be in the position to actually drill these wells before the lease expired. And it looks like, this letter from the BLM was issued the day of the last day of the hearing, but nevertheless, I believe after the hearing had concluded and the record had closed.
Okay, so I'm still fuzzy on the lease itself. So let's talk about the lease. Who is the lessee in this lease that I just listed?
3R.
3R is okay. So this lease favors you. So you were showing the division that this lease that you are the lessee would be expiring October 1st, basically saying time is of the essence. If you're going to award it to 3R, please award it as soon as possible.
Correct.
Okay. And Mr. Savage, your purpose for entering this letter from the BLM is what?
Okay, so that is a legal document. That was that material issue in the case. They made a significant argument, legal argument over that, the urgency of that document based on the legal terms of that document. The second day of the hearing, the BLM made a legal decision. Now, a legal decision is very analogous to example for a court decision who makes a legal decision on a particular matter. So the BLM made a legal decision, and what they did is they reformed the terms of that lease, so that lease no longer expires. In fact, the expiration date was extended so far that it accommodates the division's issuance of the order and the rigs to go on site and to fully develop the lands.
So,
So,
Mr. Savage,
yes.
The question I asked you was, what was the purpose of your advising us? I don't want to know all the legal
Okay.
background of it.
Well, that's all part of the foundation of the purpose. So the purpose, one very important purpose is that when the hearing examiner provides the record to the director, that it is a true and complete record. Okay, there's no false statements, there's no inaccurate exhibits, and it reflects the material presentations and arguments that were made at the hearing. The second important issue is, Mr. Suazo said that this belies the weakness of our argument. Actually, what it exemplifies is the strength of WPX's development plan.
I read your motion carefully.
Okay.
You don't have to reiterate what you said in the motion. My question to you still has not been answered. I just want a one sentence answer. What was the purpose of besides correcting the record? Well,
I don't understand that.
you don't
Mr.
understand
Hearing
why.
Examiner.
I haven't finished the sentence.
Okay, please.
I'm trying. What are you trying to tell the division by entering that letter from the BLM?
I'm trying to tell the division that currently the record has false statements.
And why does that matter to the case?
Well, under case law, you have to have a fair, accurate, and unbiased record. And under statute, the division director has to receive a true and complete record.
Yes, I understand. How does it benefit you by getting that letter in the record?
I thought I explained in the motion how it supports all the arguments that we made during the hearing. It supports all our exhibits, and it shows clearly that WPX's plan is the better plan.
Why does that letter show that your plan is the better plan?
Because it nullifies their statement that there must be some kind of urgent granting of the operatorship, and so it allows the division to set that aside and to look closely at the merits alone without considering that as a factor.
Okay, so in which of the 7 factors is urgency?
Well, 3R was the one that brought up the urgency, so they made it a central point and thesis of their position.
Well, you said it was a material issue at the hearing. Those are your words.
Because they brought it up.
If it's material, it has to matter. If it matters, it needs to be one of the 7 factors that the division considers. Which factor includes urgency?
Okay, Mr. Hearing Examiner, I would say that those 7 factors, if they're qualified, and it says the division may consider in its evaluation of competing applications of these 7 factors, but it does not limit it to those 7 factors. The 3R brought this issue up as a material issue that basically implies that they need to get operatorship because they're the ones who are ready and willing and able to jump in, as Mr. Suaze said, ready, willing, able to jump in and drill these wells, and somehow WPX is not as prepared, not as willing to jump in and drill these wells. That's the underlying subtext of what Mr. Suazo is saying. So by focusing in on this issue of urgency, they're basically trying to shift the favor of the division towards them, and we're trying to move it back to be unbiased and fair. Because those are false statements at this point.
Mr. Examiner, can I respond?
Yes, I'm coming back to you. Of course, I'm just trying to think through what Mr. Savage said before I come back to you. I mean, Mr. Savage, that idea that a lease is expiring on October 1st can go both ways in my mind. And I'm not the technical examiner or the team that develops the order ultimately. But from a legal perspective, from the hearing examiner's perspective, that can go both ways. It can cut both ways in an urgency sense. So I'm not convinced that the fact that that the BLM has now suspended the lease, allowing 3R or more time to develop that lease or to drill, weighs in either favor. So that's what I'm thinking so far, but
May I respond to that? Okay.
No,
All right, thank you.
not yet, no. And then the other document that you want to be let in is what?
The legal decision by the division itself to
And
grant.
you don't think the division knows that it granted your Bone Spring application?
That's irrelevant as in our view. It is important for it to be part of the record. If it's off the record, then, you know, who knows what anybody reviewing it would decide. The important thing legally is to have a legally valid, true record that does not present false information or statements or exhibits.
But the hearing record closed at the end of April 30th. And when did the division award WPX its Bone Spring application?
May 7th.
Okay, all right. Mr. Suazo?
Yeah, and I'm not sure that the letter from the BLM achieves as much as Mr. Savage has represented. I think that letter goes, if anything, to kind of the risk. The risk to 3R was that their lease would expire. But at the end of the day, we're confident that 3R put the strongest proposal under the 7 factors, and we stand by that. So I agree that the division obviously knows about its own orders. I'm not sure what the utility is of getting those orders onto the record. And with respect to the BLM, Mr. Savage has represented that those are now false. Well, they weren't false as of the time that the hearing closed or the record closed. And so I think it's probably prudent to leave the record as is and just let everything be, because I don't think that the decision of the division is going to turn on, these documents one way or the other.
When did you, Mr. Suazo, when did you receive the letter from the BLM?
I think it was, I don't know the exact date. I think it was in the lead up to the filings of our findings of fact and conclusions of law that we noticed that WPX was trying to get them into the record. And that's when we made our objection. Hang on, I'm going through our case outline history.
Okay, so you didn't know about it on the 2 days of the hearing?
Correct.
So, Mr. Savage, why did you not file a motion asking for the hearing record to be reopened?
Well, first of all, we did not recall that instruction or option from the division. But second, in all our years of, we relied on our years of experience before the division. We followed what we assumed was accepted procedure. In fact, in case 23448, and which we have in our exhibits, Holland and Hart actually filed a notice of supplemental motion for 3 exhibits that they came into the possession of over a month after the ending of the conclusion of the hearing.
So it was a motion?
No, it was not. It was a notice of, it was the same procedural instrument that we utilized. And that was filed. In fact, we actually had a legitimate, under the 7 factors, we actually had a legitimate reason to object to it, and we did a motion to strike. And that was because one of the factors is that the division would only consider the amount of working interest at the time of the hearing. A month later, Permian Resources had acquired additional working interest, and Holland and Hart had just counsel had filed those notices of supplemental exhibit. There was 3 of them. They're in the motion if you want to look at them. Mr. Hearing Examiner, you were the presiding hearing examiner at that time, overseeing the management of that case. The division allowed those supplemental exhibits to remain of record and to be considered in the final evaluation.
So you filed, excuse me.
Mhm.
So you filed an objection to those, right?
Based on a valid
And-
objection.
And was an order issued?
No, it was just allowed. It was disregarded, and the notice of supplemental exhibits were allowed to be maintained in the record.
It was disregarded.
Yes.
And what was the case number?
23448.
23448.
The exhibits are actually attached to the motion. They start on exhibit 2.
Okay, so you said that Holland and Hart filed what, when?
So on October 5th, 2023,
Mm-hmm.
they filed a notice of supplemental exhibit C12. That was about over a month after the end of the hearing.
Mr. Savage, that
Yes.
wasn't my case.
You assumed supervision of it.
No, sir, I didn't. We had the same hearing examiner who started that case, continued that case. So anything that was filed went to that hearing examiner. It was not me
Mr.
who made
Harrington,
any rulings. That's why
all-
nothing was done with your objection.
All post status conferences, all post motion. We had a number of motions during that time. While you're presiding that case, the original hearing examiner never made any appearance or made any comment, or she was, as far as I understood, she was excluded at that point when you came on board.
No, that's not correct, Mr. Savage.
Well, nonetheless, it's an example that this is a standard practice. It's done by established
It may have been
firms.
another hearing examiner's practice, but it's not my practice.
Okay.
There's a difference. I started here in August of 23. Any case that had been heard before August of 23, the original hearing officer worked with John Garcia on those cases. So whether you think I had anything to do with that case or not, I did not have anything to do with that case. Maybe there was a status conference, I don't remember, but I didn't make decisions about cases that I did not preside over. So let me clear that up for you now. So I don't need any more input from either council at this point. As to the orders that were issued on May 7, they're not part of the record. The division is quite aware of what it does day to day. The group that deals with those orders and issues those orders is the group that's dealing with your contested cases right now. That's number 1. Number 2, the letter from the BLM. You in your motion cite to a rule of ethics of candor to the tribunal. I don't find that Mr. Suazo was not candid with me at all about the status. I believe that he thought that that lease would expire on October 1st. However, in fairness to WPX, I am going to allow that letter to be added to the administrative record for the sole purpose of correcting the statement that the lease would expire on October 1st. So I'm going to grant your motion in part, and deny it in part. And so, Mr. Savage, you please draft the order, granting in part and denying in part based on what I've just said. Is there anything else, Mr. Suazo?
Just confirming that the record will be officially closed after that order is signed.
The record's been closed since April 30th. I'm reopening it for that one document, Mr. Suazo, and yes, the record remains closed.
Okay, thank you.
Thank you. Mr. Savage, anything further?
Yes, we think there's some important items to address as a result of that decision. First of all, we were ordered to redact and strike all references to that BLM decision. I believe that that should be reversed based on your decision.
Mr. Suazo, what's your position on that?
I guess I'd need to see how they're planning on using that language in the redacted portion. So I would need, a little bit of time to review that and then come to a conclusion, because I know it's referenced, I think 5 or 6 times in the record. So I'm not really sure. I think it depends on the usage. I think, we need to limit the usage of that letter for the sole purpose that you just explained, which is the lease expiration. I think anything beyond that is, beyond the scope and not necessary. And, the record should probably stand for itself on the balance.
All right, thank you, Mr. Suazo. So, Mr. Savage, you're proposing that I allow you to resubmit a new closing argument and a new proposed findings and conclusions.
Correct.
Is there anything else that you want?
Yes, I'd like to look at that you sanctioned WPX and publicly stated that WPX disregarded a clear ruling excluding the subject documents from the record. We would like to clear up any misunderstandings, any confusions, and and request in good faith that the division address this, because we don't see where we disregarded a clear ruling, and we're wondering if the hearing examiner would reconsider that language and statement.
I'll think about that. If you want to file something, I'll think about that.
Okay.
And I'll think about the idea that you want to submit a revised closing and a revised proposed findings of fact and conclusions of law. But at this point, the only ruling I'm making is that I will allow that one letter into the record. So please provide me a proposed order and an exhibit to that order of the letter that you want admitted. And please pass it by Mr. Suazo for his position.
And then if I understand this, then we do a motion to request the other items. Okay. Thank you.
Thank you. Mrs. Suazo, anything further before we're off the record?
No, Mr. Examiner.
Thank you, Ms. Suazo. All right, we're off the record in those cases. Is there any other business before the division, before I get off completely? I see some hands raised. I see.
Those are Mr. Samaniego.
They're both?
They are.
Actually, Mr. Examiner, there's a John Slagle. He's actually with my client. I didn't see his hand until just now.
Oh, okay. I'm not sure who that is. Can they turn their screen on for me?
I'm sorry, I must have accidentally clicked the hand raise there.
Oh, okay, no problem. Is there anyone else who wants to address the division before we conclude today's business?
Mr. Hearing Examiner, this is Matthias Sayer. I was hoping to just ask a question of you related to consolidated cases 25228, 25301, and 25303.
Okay, would you identify yourself first, please?
For sure. Matthias Sayer with Bradfute Sayer.
Oh, yes, this has to do with the motion regarding the July 1st contested hearing.
Correct.
Okay, yes.
Yeah, and appreciate your response to the motion. However, was hoping that you might be able to provide a little bit of context as to why the motion was denied. It was an unopposed joint motion, entered in good faith. And
Mr. Sayer, I listed the reasons for the denial in the order. What I stated was that the cases were filed in February. So first of all, they're old and we need to move them along. Second of all, the witness, we're only talking about one landman witness for PBEX. That landman can testify from anywhere they are in the world virtually, as long as they have a screen for me to see them and swear them in. And if for some reason that landman cannot testify virtually, then at the end of the hearing on July 1st, we can set a new date for that one witness to testify in the future.
Yeah, and I appreciate the explanation. Our concern is that it's not just the inability to be present in Santa Fe. It's that this situation requires them to be engaged in other activities leading up to and on the day of the hearing. And while, again, appreciate the trying to work in some flexibility in creating a second window of time to conduct a continued hearing, nevertheless, PBX would be prejudiced by not having their expert, their land expert available during the first portion of the hearing. And furthermore, they would miss the entire first portion of the hearing and thus would not be fully aware of issues discussed and presented at the first portion of the hearing, all which would end up in a second hearing, or a second round of hearing, likely occurring at some point in August anyway, which is what we had requested initially. So I appreciate that you're trying to satisfy interests of administrative economy, but it doesn't seem that those interests would be served while simultaneously PBX will be prejudiced. And then also wanted to note that PBX's cases were not filed till the end of March.
Right.
March 28th.
Right. Well, there are two parties. It seems like the parties were depending on your late filed motion to be successful because the parties have not filed evidence and a pre-hearing statement as the rule and the pre-hearing order requires. I have to say that that tells me something. The way that was handled, that tells me something about the urgency of the matter. The witness will have a transcript to review. The hearing on July 1st will be recorded for the witness to review before she testifies. There just are no more dates in August to offer you, and I'm not willing to bump this down into September.
Well, I appreciate that, Mr. Hearing Examiner. I will say what it should also tell you that those weren't filed is that there was some presumption, based on precedent and history, that when a joint unopposed motion is filed on grounds such as these, that a tribunal or an administrative judge or someone in your position typically, responds a different way to that type of motion. So that's also a bit surprising.
Okay, I'm sorry you feel that way, Mr. Sayer. Is there anything further?
No, we will be filing a motion for reconsideration later today.
So you're not filing any evidence, you're just continuing down this road?
We're filing a motion for reconsideration.
Thank you, Mr. Sayer. We're off the record.
Thanks.
And that concludes our business today. Thank you.